first memo really deals with cases brought under the whistleblower provisions of the False Claims Act and talks about situations where the government has decided it's going to decline to intervene. The memo arguably encourages department attorneys to think about whether it's appropriate to dismiss the case. That authority is authority provided under the False Claims Act. It's been in existence for a very long time. The reality is, and the memo concedes, that it's an authority that the Department of Justice really rarely exercises. And it sets forth 7 factors, not intended to be exhaustive, that department attorneys can think about determining whether not just declination, but dismissal is the appropriate remedy. The memo speaks to a gatekeeping function, that the department actually has a gatekeeping function to protect the False Claims Act. So entities and individuals faced with False Claims Act investigations and litigations ought to be using this as a tool early on to argue not only should the government not be involved in the case, it should exercise that gatekeeping function and dismiss the case outright. So the second memo speaks to cases brought affirmatively by the department. And it tells prosecutors that you can't rely on supposed non-compliance with agency guidance as either a presumptive or conclusive evidence that a False Claims Act violation has been committed. Government agencies issue memoranda and directives all the time. And it's not uncommon, frankly, for False Claims Act investigations to be initiated as the result of reported failure to comply with that guidance. But that's not rulemaking. Guidance and memoranda and directives don't have the force of law. They're not subjected to the Administrative Procedures Act, and the memo effectively says to department attorneys, don't treat it as such. The memos don't change risk for healthcare board members or executives. They are tools that can be used when False Claims Act investigations are pursued against them and should be affirmatively. I think the overall risk remains the same, frankly, since 2015. We've seen a continued focus by the Department of Justice on holding individuals accountable. You've seen individual settlements. You've seen settlements where individuals have been held jointly and severally liable. I don't expect that that's not going to continue. There are real-life examples of cases being pursued and settled with CEOs, CFOs, company founders, even the chair of a board of directors. Those risks are real. But what I think the memos provide are additional tools for their counsel to say, this is not the right case to bring. You should dismiss the case. Or in the case of the second memo, this is a case that is not appropriately based. This is not a case based on anything other than a purported failure to comply with agency guidance. That's not sufficient. You shouldn't pursue that case.